Hello friends, my name is Natalia Porsche and I'm an attorney. Welcome to my YouTube channel. And in this channel, I discuss immigration issues, I discuss family law issues, criminal defense laws, and DUI laws. Okay, so welcome to my YouTube channel. I hope you like this video. If you like this video, put thumbs up. So today we're gonna discuss why motion to reopen in immigration court is a very important, specifically if you was deported in the past and now you have relief that is available to you under immigration law. Okay, so for instance, if you was previously deported in immigration court and now you're eligible for some sort of relief under immigration law, you can file a motion to reopen. Motion to reopen is the procedural tool that is widely used by respondents and practitioners, their attorneys, if they are represented, to reopen their cases based on new facts and evidence, something that occurred after immigration judge granted a removal order. There are different kind of removal orders. One of the kind, it's a removal order in absentia. What does it mean? It means that you did not show up to your immigration court hearing and therefore the judge ordered you to be removed. Keep in mind, if you fail to show up to your immigration hearing, the judge will order you to be removed from the United States unless you have an attorney who waived your appearance. That's also possible. So let's say you have a removal order in absentia and you fail to show up for some very important reason. Therefore, you can reopen your case if you have a relief available to you. Keep in mind that when you file your motion to reopen, you also must attach a relief that is available to you. For example, an application for asylum, 589, right? I-5 and 89. You must attach that application to show to immigration judge who ordered you a removal that you have an option available to you, option of relief under immigration law. Therefore, you are eligible for the relief and therefore you are eligible to reopen your deportation case and start your deportation case again, seeking the relief that you available for. Okay, so when you file your motion to reopen, you must tell the judge again what relief you are seeking. Okay, it's called content of the motion while you're reopening your case. There are specific time limitations when you file your motion to reopen. The law states that the motion to reopen must be filed within 90 days after the judge ordered you to be removed from the United States. There are exceptions to this rule, and also there is a limit on how many times you can file your motion to reopen. For example, the motion to reopen under the statute, under the law, can be filed only one time, so you have one shot at it, right? However, if you file your motion to reopen based on a change of conditions in your own country, and now you're seeking to reopen your case, you're filing your application for asylum, withholding of removal, and withholding of removal under Convention Against Torture. Now, this is an exception that does not apply here, so therefore, this exception provides that even if you file a motion to reopen in the past, you still are eligible to file your motion to reopen if country conditions change. And of course, with your motion to reopen, you must attach a proof, new evidence that the conditions in the country of your origin has changed dramatically, that if you are to return back to your home country, you will suffer, for example, harm, right? Please treat this information as a general information. This is not a general advice. This is not an attorney's advice, okay? So you must seek an experienced attorney regarding your own case, right? To speak with an attorney about specific facts of your case. This is only an educational video. Okay, so again, 90 days you have to file your motion to reopen under general rule. There is another exception that the judge, asking the judge to reopen your case, called sua sponte. Sua sponte is something that court can do on its own motion, right? So you're asking the judge, well, I want to reopen reopen my case because I filed, for example, a form with USCIS, for instance, I-360. So you're looking to adjust your status here in the United States, and therefore you are eligible for the relief, and you're asking the court to reopen your case to sponte. That means on its own motion. So next, there are filing fees, of course, when you file your motion to reopen. However, you can seek a waiver. You have to fill out the form seeking a waiver. Also, if you file a motion to reopen based on application for asylum, there are no filing fees. So this is an exception to filing fees. Okay, so let's say if your case, here's very important information. If your case was administratively closed, for example, you've been granted the prosecutorial discretion to close your case, or the prosecutor a trial attorney agreed to close your case. Therefore, you have to file a motion to recalendar instead of motion to reopen because your case was never formally closed. So this is another thing that you have to watch out for, okay? Again, if you change your address since you moved, for example, after the removal order was issued by an immigration judge, you have to submit form EOIR 33, which is a form which provides, you have to fill out this form, and this form provides your new address, okay? Again, motions to reopen, they can be very tricky. That's why you have to look for an experienced attorney, seek an advice specifically relevant to your case. Like I said, I have a bunch of educational videos here on my channel. However, they're only educational. If you need a further information, you can contact my office. The phone number is down below. It's 228-229-7500. We are located in Biloxi, Mississippi, and we practice immigration law in all 50 states in the United States. You also can go to my website, nataliaporsche.lawfirm.com. You can see it down below or up here, and you can book your appointment so that we can talk about your case, the specific facts of your case, and see if you're eligible to reopen your case. You also have to watch out. There are specific things that apply if you are in custody, right? If you're in custody, in ICE custody, and you have a prior order of deportation, you got to be very careful here. You definitely need an experienced immigration attorney on your side. You also will need an experienced criminal defense attorney if you have a pending felony or misdemeanor charges. And this is whole another topic, guys. And I will make another video here on YouTube about how you reopening your case where actually you are ICE custody. If you have an immigration detainer and you have been charged with a crime, and now there is a prior order of deportation, but you never left the United States, which is very important point, right? So you still can seek to reopen your case. And like I said, I will make another video about that. It's very complex issue, and you definitely need an attorney who can understand criminal and immigration law all together. If you have a public defender, for example, your immigration attorney can get in touch with your criminal defense lawyer and discuss specific little small things which will make the whole difference in your life, which might save you actually from being deported. Again, thank you for watching this video. If you like this video, subscribe to my channel, put thumbs up. Thank you, and all the best to you. Good luck.